Very, very warm good afternoon. I consider it as a profound privilege for me to be given this opportunity to address this august gathering consisting of such eminent members of bar, judges of court, and I am here to share my thoughts on the idea and evolution of the idea of constitutional morality and how we have dealt with the idea of constitutional morality in this country in our times. So, as a teacher, I'd go to the history, the origins of the term, and I'll take you back to the debates of Constituent Assembly. I've been studying them extensively, and I've been deriving all through my academic journey. I've been deriving a lot of research material from those gilded volumes of Constituent Assembly debates kept in your library in the corner, parked safely for future generations to refer when time comes. So let us go back to the Constituent Assembly. The first meeting of the Assembly was held on 9th of December 1946. Yes, it was the British era. They only convened Constituent Assembly. The first meeting was held on 9th of December 1946. And the Assembly continued its deliberations for 2 years, 11 months, and 17 days. This was spread over 11 sessions. The first 6 sessions of the Assembly were focused on considering and adopting the objectives resolution, the reports of Committee on Union Constitution, Provincial Constitution, on fundamental rights, on minority affairs, scheduled areas and scheduled tribes. And the remaining 5 sessions were dedicated and devoted to the debates on draft constitution. So as many as 165 days were taken by Assembly to debate this constitution, whereby 114 days were taken to debate the draft constitution. Fact of the matter is that the first draft of constitution is prepared by Benigal Narsingh Rao, who was the constitutional advisor to the Constituent Assembly. The draft having been prepared by the constitutional advisor is submitted to drafting committee, which consisted of 7 members and was chaired by Dr. Ambedkar. While moving this draft before the Constituent Assembly, Dr. Ambedkar made very poignant remarks on the floor of House on 4th of November 1948. It is this speech where he has used the expression constitutional morality on multiple occasions. If I may count, there are 3 references to constitutional morality in the speech, which I am going to quote in extenso over the course of next few minutes. Dr. Ambedkar, when he tabled the draft, he was met with criticism that there is nothing new in the draft constitution and that half of it is copied from Government of India Act 1935 and that the rest of it has been borrowed from constitutions of other countries. Very little of it can claim originality. So plagiarism doesn't affect the teachers only. The Assembly said that the constitution itself was facing issues concerning originality. And you look at this beautifully drafted response by Dr. Ambedkar, where he defends the draft constitution despite the fact it lacks originality. You listen to the words. I mean, my students will be benefited. All the distinguished members of the bar, the judges, they already know of this. But my students will be benefited, and for their benefit alone, I'll refer to this speech in extenso. Dr. Ambedkar says, and I quote, "One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries reducing their constitutions to writing. What the scope of a constitution should be has long been settled. Similarly, what are the fundamentals of a constitution? They are recognized all over the world. Given these facts, all constitutions in their main provisions must look similar. The only new things, if there can be any, in a constitution framed so late in the day are the variations made to remove the faults and to accommodate it to the needs of the country. The charge of producing a blind copy of the constitutions of other countries is based, I am sure, on an inadequate study of the constitution. I have shown what is new in the draft constitution, and I am sure that those who have studied other constitutions and are prepared to consider the matter dispassionately will agree that the drafting committee, in performing its duty, has not been guilty of such blind and slavish imitation as it is represented to be. To the accusation that draft constitution has multiple provisions borrowed from the Government of India Act 1935, Dr. Ambedkar acknowledges and he says, I will make no apologies for having done that. And he again quotes, there is nothing to be ashamed in borrowing. It involves no plagiarism. Nobody holds any patent rights in the fundamental ideas of a constitution. What I am sorry about is that the provisions taken from the Government of India Act 1935 relate mostly to the details of administration. I agree that administrative details should not have a place in the constitution. I wish very much that the drafting committee could see its way to avoid their inclusion in the constitution. But this is to be said on the necessity which justifies their inclusion. He quotes Grote, the Greek historian, that diffusion, and this is where the reference to constitutional morality begins, the diffusion of constitutional morality not merely amongst the majority of any community but throughout the whole is the indispensable condition of a government at once free and peaceable, since even any powerful and obstinate minority may render the working of a free institution impracticable without being strong enough to conquer ascendancy for themselves. He quotes further and explains that by constitutional morality, Grote meant a paramount reverence for the forms of the constitution, enforcing obedience to authority combined with the habit of free speech, of action subject only to definite legal control, and unrestrained censure for those very authorities as to all their public acts, combined too with a perfect confidence in every citizen amidst the bitterness of party contest that the constitution will not be less sacred in the eyes of the opponents than in his own. So in a way, Dr. Ambedkar on the floor of Constituent Assembly is lecturing future generations that constitutional morality is about reverence for the forms of the constitution, enforcing obedience to authority. It's not just that, but first he refers to obedience to authority as long as the authority works within the limits of law, and it is combined with the habit of free speech, of your ability to question the actions of the authority within legal parameters, and the unrestrained censure of those very authorities as to their public authority, public actions, combined with the confidence in every citizen that all citizens will agree to abide by the constitution and will alter their conduct according to the mandate of the constitution. It is very important to understand that everybody recognizes the necessity. So on why he was referring to constitutional morality and the link with the provisions borrowed from Government of India Act 1935, Dr. Ambedkar says that these provisions that have been borrowed from the Government of India Act 35 essentially deal with administrative issues. These are not fundamental rights. These are not, the functioning of Parliament, the Supreme Court structure, etc. But these relate with administration. And then he goes on to explain why it was important in the opinion of drafting committee members that these provisions be included in the Constitution. Dr. Ambedkar says that constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people have yet to learn it. Democracy in India is only a top dressing on the Indian soil, which is essentially undemocratic. In these circumstances, it is wiser not to trust legislature to prescribe forms of administration. This is the justification for incorporating provisions of Government of India Act 1935 in the draft constitution as presented to the Constituent Assembly in 1948. And many of those provisions have been retained in extenso in the present constitution. What is important from Dr. Ambedkar's perspective is that the doctrine of constitutional morality primarily translates to respect among stakeholders in a republic for constitutional democracy as the accepted form of governance and administration. This was all the more relevant at the time of exposition of the inauguration of the Constitution and India's transition into a republic. The doctrine defines the nature of relationship between the state, the citizenry, and the political actors, wherein every stakeholder is committed to constitutionalism in public life. Constitutional morality translates to greater obligation on the part of state authorities to conduct themselves in accordance with the Constitution instead of behaving like feudal landlords. So in sum, we can say that constitutional morality translates to people respecting the authority of the state so long as the state is acting within the bounds of the Constitution and having constitutionally guaranteed the right to vocally call out state authorities for their transgressions, if any. It is important that whenever a legislation is enacted, all lawyers know, as law teachers, we also teach our students that there is a presumption of constitutionality of a statute. You start with the point that the statute enacted by legislature, Punjab Vidhan Sabha, by Parliament is constitutional, is constitutionally good. And if you are challenging that it is not through the legal process, then the onus of proof is on you. This is what constitutional morality is, that you owe your loyalty to the state as long as the state is acting within the confines of the law, and you retain the right to vociferously object to excesses by the state, by the legislature or by the executive, where they have exceeded their brief as allowed to them by the Constitution. Again, I would like to focus on the idea of constitutional morality vis-a-vis public morality. Fact of the matter is that constitutional morality, Nirmalji, please guide me about time. Whenever my time is over, I'll just finish. I'll just take. So I'll try and summarize. I'm in habit of lecturing. If I were not here, I would have been in a class, and it would have been a lecture on.
The topic is more or less jurisprudential in nature, and students can correlate that it is a jurisprudence class and the professor is giving a lecture.
So, thank you for saying that. So, I was about to discuss the very poignant, very important issue whether constitutional morality is same as public morality or morality which finds a mention in the Constitution. Constitutional morality doesn't find a mention in the Constitution, but there are multiple references to morality and to public morality in the Constitution. And my students will agree with me that when Article 25, which confers the right to freedom of religion on the citizens of India, begins with words like subject to public order, morality, health, and other provisions of this part, every citizen is equally entitled to freedom of conscience. Similarly, Article 26 also incorporates the word morality there, subject to public order, morality, and health. It goes on and on. Similarly, Article 19 Clause 2 provides reasonable restrictions in case of free speech, and the grounds on which free speech can be limited, there are 8 grounds, but these grounds, public order, decency or morality, are relevant for today's talk. Similarly, Article 19 Clause 4 also refers to restricting reasonable restrictions in the interest of sovereignty and integrity or public order or morality. What I would submit that at this stage I would submit that the morality that is being referred to in these articles, in Article 19 Clause 2, Article 19 Clause 4, Article 25, 26, it is public order or morality. So the word public will regulate the use of word morality here. So what the Constitution is referring to is public morality. And so, by the way, morality and public morality finds a mention in multiple statutes also. Statutes like Cinematograph Act of 1952 refers to it, White Section 5B, Clause 1, the Airports Economic Regulatory Authority of India Act of 2008, the Indecent Representation of Women Prohibition Act of 1986, Designs Act of 2000. There are multiple statutes which refer to morality. So the question that is worth asking at this level is the morality that statutes are referring to and the public morality that Constitution is referring to, is it the same as constitutional morality? Or constitutional morality is different? The courts in India have explained that morality, the expression public morality relates with prevalent standards of societal morality. That is, what a society at a given point of time deems morally permissible or impermissible based on its cultural and civilizational moorings. You have to understand that public morality is more about what is acceptable to you. It is not about what is acceptable to the text of the Constitution. What is acceptable to draft of the Constitution, the provisions of the Constitution, what is the spirit of the Constitution, the kind of morality Constitution wants to inculcate in the citizens may be at variance in some cases with the public morality prevailing at the time. This is the issue which has been invoked before Supreme Court in multiple cases. I will because time is limited, so I will immediately come to the litigation in Nalsa versus Union of India, the case that ultimately led to Justice K.S. Radhakrishnan writing a beautiful judgment recognizing transgenders having the right to be recognized as third gender so far as Indian state is concerned. So prior to that, only male and female were the two genders in government institutions, for jobs, for educational institutions. They were required to either to take the category of male or female, and that resulted in discrimination, very latent discrimination against them, because they were not able to fix themselves in those fixtures of male and female. And the case itself, the petitioners, which included many victims, including one Miss Lakshmi Narayan Tripathi, who in the petition argues that she was born in a male body, but she never felt like she was a male, and so all through her childhood she was subjected to very vile treatment by colleagues, by relatives. She was subjected to sexual harassment. And the petitioner's case was that because the state insists that you can either be male or female, and I am someone whose lived experience is different, so state has actually legitimized victimization against transgenders. This is something with which Justice Radhakrishnan agrees in his judgment. Uh, and if I may quote the very if I may quote the petitioner, and these are the words from which I have borrowed from the judgment in Nalsa versus Union of India. Lakshmi Narayan Tripathi is on record. She's saying that growing up as a child, she felt different from the boys of her age and was feminine in her ways. On account of her femininity, from the early age she faced repeated sexual harassment, molestation and sexual abuse, both within and outside the family. She was constantly abused by everyone as a hijra. Though she felt that there was no place for her in the society, she did not succumb to prejudice. She started to dress and appear in public in women's clothing in her late teens, but did not identify as a woman. Later, she joined the Hijra community in Mumbai, and she identified with other Hijras, and for the first time in her life, she felt at home. This was the petitioner's story. And in the judgment, if you, so I'll just take another 2 minutes. In the judgment, finally the court has looked at this from very, very human rights perspective, from the perspective of constitutional morality, and the Honorable Supreme Court delivered a judgment whereby they recognized the existence of third gender in the country. They directed Union of India and state governments to recognize the third gender as a category, not just in census but in other government appointments. And let me tell you what is the success of this judgment. What is the success of the recognition of rights of transgenders in Nalsa? Post this judgment, the same Lakshmi Narayan Tripathi who feels that she has been violated, discarded by society, she is on record that post the judgment, she today occupies the high office of Mahamandaleshwar of Kinnar Akhada that came to be established in 2018, and she participated in the the Kumbh Mela of Prayagraj in 2019 as a Mahamandaleshwar. That has, so constitutional morality activated by court has resulted in social change, and it has also changed public morals. It has resulted in change in acceptance of this community. There may be multiple other cases that I can cite, but I would like to just briefly refer to one more aspect, and then I'll wrap up my presentation. So, in the very beginning, I gave you a quote from Dr. Ambedkar, where he's arguing on the floor of Constituent Assembly that constitutional morality is about a citizen's commitment and loyalty to the affairs of state, as long as state is acting within the confines of law, and citizen retains the power to question state when the state exceeds its brief. Few years back, because and this is only because I teach a course in citizenship and immigration law at the university for past 6 years, so I've developed some understanding of India's citizenship law. Few years back, we had this very, very we had this legislation in Citizenship Amendment Act of 2019, which resulted in a lot of criticism of state action and a lot of protest also. But there was vociferous protests. The matter has reached court and it's pending before Supreme Court, the constitutional bias. But I could never understand the myth making around this amendment. It's not just one amendment, but there can be multiple provisions in law that can be talked about in this session. But I'm focusing on this because I know my students have been very, very interested in this area of law, this development in law. So what has happened during the protests is, the argument was that state cannot classify, you cannot discriminate on the basis of religion, you cannot discriminate on the basis of countries of origin of the refugees coming to India, you cannot come with an artificial date of 31st of December 2014 because it is arbitrary, so it is unconstitutional. But on all three grounds, I felt that somehow we have led ourselves to go astray by political motives. I am not not on the point whether government should politically bring this legislation or not. I'm speaking from the law perspective, and from the law perspective I can say that in India we have series of legislations where benefits are conferred on one particular category looking at their own historical perspective. I would like to cite the example of Article 290A of the Constitution, which provides that funds to be released to the temples of Travancore and Tamil Nadu, temples belonging to a certain religious community, from the consolidated fund of Tamil Nadu and Kerala. 290A is the constitutional provision. Similarly, when it comes to the identification of scheduled caste, scheduled tribes, the scheduled caste order of 1950 is very clear that certain religious groups are to be given the benefits and there are others to be excluded. So this was not the first statute where exclusion was happening on account of religion. Similarly, when it comes to benefits being conferred to the country of origin of certain citizens, this again was not the first statute. The very Citizenship Act, Section 7A, which talks about persons of Indian origin and OCI cards, there again, there is an express mention that those having origin in Pakistan and Bangladesh will not be considered for benefits conferred by Section 7A of the Constitution. So these are the basic thoughts. Because I am running short of time, I will not discuss the judgment in Harendra Rai versus State of Bihar, which was delivered by the Honorable Supreme Court on 18th of August, just a couple of days back. But it's a wonderful judgment, and I request my students, CRPC students, to please read it. Thank you so much. Thank you.
Thank you so much, sir.